All right, good morning, everyone. Let me share my screen and let me present my screen, sorry. And let's get started. Let me move this down here, out of the way. Today we're talking about the eviction process, start to finish. Really excited to be talking about this process. It's complicated, it can be painful, and it can be cumbersome. So not much to say beyond that, but it's a very important topic to be covering, particularly in property management. Welcome, we're glad you're here. We're going to be discussing the eviction process, as I said. You can utilize the comment section below this video to ask questions and offer feedback throughout the webinar. My name is Matt Zalk, owner of Keyrenter Tulsa and Keyrenter Oklahoma City. Over the past few webinars, we've discussed various topics. The first one was benefits of using a property management company. Second, how to calculate rental return rates for your properties. The third was best practices for screening tenants for your rental. If you are not using a property management company, if you did not properly screen your tenants, then today's topic, how to evict your tenants, is particularly important. We oftentimes get property owners that come to us and say things like, we had a great tenant, they were 3 or 4 years, they paid rent on time generally, a couple times they were late, and now they've just fallen off the map. I thought we were friends, I thought we were, had a cordial business relationship or whatever, and somehow they've stopped answering my phone calls, they've changed their phone number, they've this, that, and the other. Every time they come by, every time I go by to collect rent, they're not there, or they pretend that they're not there. I see their car and their dog is there, but they're not there. So can you guys step in and be the bad guy? Of course, we're I can't say excited to do it, but we do it. It's one of the services that we offer as a property management company. And so we're very familiar with the process. We also sometimes have people come pulling out their hair and screaming, I just retained an attorney for $1,300. And now I don't quite understand the process, but I've got this and it's underway or something like this. I would say, generally speaking, paying $1,300 to retain an attorney to handle this sort of process is exorbitant. I wouldn't do it. I wouldn't recommend it be done. If it's not a real estate attorney that knows exactly what the process is, don't give money to anybody that tells you they can, handle an eviction for you. My 2 cents. There are 2 reasons to evict a tenant: non-payment of rent and other lease violations. There's a third, really, and that is illegal activity we'll get into in a second. But the 2 main reasons that you evict a tenant is because they don't pay rent, very simply, right? They get behind, there are late fees that accumulate, they lose their job, and they continue to get further and further, and they just aren't paying, and so you need to evict them. Or there's other lease violations. They are, they're not taking responsibility for mowing the grass, for example, or the front yard is totally disheveled. There's stuff everywhere, or they aren't reporting real serious issues in plumbing or leaks or whatever, or they have not kept the place in to a reasonable standard. They're hoarders, and there's just mice and roaches everywhere, stuff like that. The OSCN, the Oklahoma State Courts Network, says the district court shall have jurisdiction to try all actions for the forcible entry and detention or detention only of real property, and claims for the collection of rent or damages to the premises, or claims arising under the Oklahoma Residential Landlord and Tenant Act. So all of that is to say there's a forcible entry and detainer, an FED, can be granted for failure to pay rent or another violation of the lease. So there it says claims for the collection of rent or damages to the premises, or claims arising under the Oklahoma Residential Landlord and Tenant Act. To evict a tenant, you'll need a lease or another document that explains what back rent is owed or what the clause of the lease being violated is. So you cannot not have a lease and say to somebody, you owe me rent plus this late fee for the previous month, 2 months, 3 months. There needs to be something in writing that claims or that indicates what the damages would be. In the case of non-payment, the damages would obviously be the rent that has not been paid and what needs to be collected. If you don't have a lease for your property, that is a problem. You theoretically are in month to month, in some sort of month to month arrangement. There may have been a lease in the past. It may have been 5 years ago that you signed a lease and you've just never renewed that lease. That's not best practice, certainly, but you can use that lease. You can use the previous lease and just claim you're in a month to month, which you are legally and technically, to show violation of the terms. So if your lease from 2014 says that this person should be paying you $600 a month in rent, then they should be paying you $600 a month in rent plus $25 of late fee or whatever that lease says, and you can use that as the legal document ascertaining your claims to what is owed. If you're evicting for non-payment of rent, the first step is that you'll need to issue a 5-day pay or quit notice. Generally speaking, we let's talk about our process. Rent is due on or before the 1st. We have all sorts of leases that have been passed over to us that we've absorbed or inherited because we've taken properties on in the middle of their lease cycle. And so we don't send out a 5-day pay or quit notice until the 6th of the month, because we have many leases, even though ours says it's due on the 1st and late by the 2nd, and we are legally allowed to post a 5-day pay or quit notice on the 2nd for those tenants that are on our lease. We will, just to avoid confusion among our property managers, we will always post 5-day pay or quit notices on the 6th. There will come a day in the future when all of our residents will be on our lease and we can post it on the 2nd, but until that time comes, we post it on the 6th, except for extenuating circumstances. And so we'll post it on the 6th. It says, "Dear tenant, you have 5 days to pay this rent, or we're going to begin the process of eviction." So this is the form that we use. The obligation is, as we'll see here, let's go to it in a second. I won't go through the obligations yet. So you've got a 5-day pay or quit notice for non-payment of rent. If you're evicting for other lease violation, which according to the Landlord-Tenant Act is called material non-compliance, you'll need to issue a 1015 notice. The 1015 notice tells the resident that they have 10 days to remedy the breach, or 15 days, or in 15 days the lease will terminate. Of course, in the scenario where the lease is going to terminate because they have not remedied the breach that you've identified as the landlord, you can imagine that the person is not going to just say, "Oh, the lease is up in 15 days, perfect, I'm moving out." So generally speaking, you will have to actually go through the forcible entry and detainer process. That is the court process, right? A small claims suit to actually get possession of the property and then lock them out, which we'll go through in a second. There's also the ability to execute an immediate eviction because of illegal activities such as crime or drugs. And so you circumvent the process of issuing a 5-day pay or quit notice or the 1015. You'll only have to provide 24-hour notice of eviction and then file the necessary paperwork. Of course, in any of these scenarios, whether it's a 5-day pay or quit, a 1015, or a 24-hour emergency notice, there's the rest of the process, which is actually filing in court. We're going to see that here in a second, but there's the filing in court, getting a court date, and that could be, a 2-week process. So it's certainly not an immediate thing. I don't want you to think that issuing a 24-hour notice of eviction, emergency eviction, is an immediate thing, like you're going to be able to drill the locks out in 24 hours because they've broken the law. For any of these, you need to either serve the notice in person to the tenant of the property, or deliver the notice to any family member of the tenant over the age of 12 years old that is residing with the tenant. So if somebody's there, you can issue them, and you believe that they're 12 years or older, you can issue them the notice, personally, by putting it in their hand. You can also, if you're unable to serve them personally, you can also post the notice in a conspicuous place on the dwelling unit and mail it by certified mail. So technically certified mail is just the proof that you need when you go into court to show that that piece of paper was mailed. There are other ways to prove that. I won't go into them here, but certainly if you're filing a lot of evictions, there are other ways to do it. So if the rent is not paid with the 5-day pay or quit notice, or if a violation is not abated per your 1015, the landlord has to go down to the courthouse and file the affidavit and summons to appear in court. So this piece of paper is 2 things. Technically, it's an affidavit showing that you've done what's necessary from your side as a landlord to for them to pay and request payment, or request that they abate the breach. But it also is a summons, a legal summons for the tenant to appear in court at a specific time and date. So it advises them that they've been sued and that they should appear in court should they choose to do so. The affidavit of the forcible entry and detainer is the part that is the notice that they're being pulled to the small claims court. The landlord must serve the filed affidavit to the tenant either by hiring the sheriff's office to do that or by hiring a private licensed process server. The cost is generally between $50 and $100. So you can go down from the courthouse and pay the money to the sheriff to have the sheriff serve the affidavit to the tenant, the summons to show up to court, or you can hire a private licensed process server. It's important that you hire somebody that is licensed because at some point there's going to be a request for an affidavit. Somebody's going to have to swear to the court that the affidavit and the summons was actually served, and it's important that that person be licensed. Otherwise, it's not valid. Once this summons and affidavit is served, there's the actual court date, and that court date is a small claims court date. So the landlord or an attorney representative for the landlord must show up in court on the assigned day so that they can represent the plaintiff in the case. Of course, the defendant, who's the tenant in this case, is also going to show up. And this is on the left-hand side is a real result of the day that the court case takes place. So there are a bunch of options. The defendant at the top, you can see there's a date. The plaintiff and the defendant are both named, and then it says whether the defendant actually showed up. If they don't show up, it's uncontested, and the landlord is granted, by virtue of the defendant not showing up, the landlord is granted possession of the property. If they do show up, there could be a judgment for an amount and for possession, and that then can be taken to the next steps, an asset hearing, or you can actually to try to get the money, or you can actually just submit it to a collections agency, or you can attempt to collect yourself. So this is a judgment for possession of the premises and for the actual amount. If the forcible entry and detainer is granted, the landlord must then return to the courthouse a couple days later to have the judge sign an execution that grants them the right to schedule the lockout. So it has to be served. The execution has to be served, again, either by hiring the sheriff's office or hiring a private licensed process server, because I think the court wants to ensure that it actually gets served. And private licensed process servers have taken an oath saying that they will not lie about whether they serve a piece of paperwork, and that is their core job, right? They'll go out until they're able to serve it in a way that's legal. So whether it's posting it appropriately or actually finding the person, etc. This notice, this execution, gives the tenant 48 hours notice to vacate the property. After that period, the landlord is legally granted possession of the property. So that is the time at which you can actually drill out locks. You can just take a key and enter, but it's not always that easy, right? If there's a situation where the tenant, the defendant, will not leave the property, then you have a situation that could get violent, dangerous. It could just be ugly. Sometimes you go into properties, after the 48-hour lockout notice, and it's just disgusting, right? You have all sorts of issues. So there's no real danger except to potentially your health for entering a property that's absolutely abhorrent in appearance. But it's sometimes you just don't know what you're going to find. So you go in with the sheriff, they do the lockout, they knock and announce themselves. You maybe open up the lock with the key. Maybe you do it by drilling out the lock, and then the sheriff goes in and actually clears the facility. So it might mean that they take the tenant and the possessions and put them on the corner. Thank you very much for being here. You're no longer welcome. Or they just clear the property and say, nobody's inside. They've already left. You have possession now. And the sheriff will generally call you beforehand and say, hey, I'm going to be on time. I'm running late. I'll meet you over there whenever. It's important to notice that it's important to realize that the sheriff will need to enforce the 48-hour notice to vacate. if things are dangerous, I mean, you don't want to be a hero here, and you don't want to end up walking into a property where somebody is unstable mentally or otherwise because they're being kicked out of their property. But at the same time, the sheriff won't enforce the notice unless they previously serve the notice. So you cannot say, I want a private process server to serve the notice, and then when things get ugly, call the sheriff. The sheriff will then need to go back and serve the 48-hour notice themselves, so that they can do the lockout. So that's super important to realize. If you think that it's going to be kind of an ugly situation, always have the sheriff do it. If it's not, and you think the person's already gone or something, then do it with a private process server, no problem. We've gone into, just anecdotally, we've gone into properties and they've just been, there have been pets still there, pets that have been stuck inside a house. They have food, maybe they don't have food. They've defecated and urinated all over the property. Windows are broken. We had one where the back windows were broken and the dogs were just running wild around the neighborhood. In the evenings, they were coming back to sleep. They were jumping through a back window and coming back to sleep. In the meantime, they were terrorizing the kids of the neighborhood, just this like roaming pack of dogs. And of course, everything was left. Just when you have animal feces everywhere, then you have flies, and flies are stuck on those little curly strips. It just was awful. Luckily, we actually cleaned the place up, painted it, refreshed it a bunch, and put in great tenants. That was a small victory. Once the eviction is complete and the tenant's out of the property, it's ready to clean, fix up, and re-rent. And we want to, of course, get it back on the market as soon as possible to start making some money. So, oftentimes when you have an eviction, it's rare that you have an eviction where you walk in and the place is immaculately clean. There was a 740 credit score that just stopped paying rent and has left. But in the process of leaving, they did a wonderful job, skimming the pool for leaves and doing the proper chemical treatment, touching up the paint of where they hung their pictures on the wall, and then dusted the carpet on the way out. So you can imagine that you're going to find properties in varying states of disarray, but oftentimes they're going to be absolutely filthy and disgusting. So it's important that you call the junk hauling company or your cousin with a flatbed truck to just start hauling stuff away. There are in the Oklahoma landlord tenant rules, there are specific durations that you need to oblige. If you think that there is stuff in there that is of value, you need to hold that property for a specific number of days before you get rid of it. And you can sell it theoretically for the debt incurred by the tenant, or you can trash it, right? If there's nothing of obvious value, or you don't think that there's stuff of value, then you are able to throw it away. If it's just old junk, right? But that is a subjective determination. And so it's sometimes wise just to keep everything for 15 or 30 days until that duration passes, and then you can toss everything away. The other things that are worth mentioning, there are a couple of other rules in the Landlord Tenant Act of I think it was revised in 2018, that are worth noting. But generally speaking, once an eviction takes place, you're free to go in and dispose of the property. The stuff inside, there's rarely anything of much value. But so get your cousin that has a flatbed truck, haul everything out, do the touch up, fix sheetrock. There's going to be dust and dirt and nastiness, in various spots. Clean the fixtures, paint where you need to, fix countertops, and then get that property re-rented as soon as possible. Before you do that re-renting, go ahead and watch the video that we made that is about best practices for screening tenants for your rental. There's a bunch of good information in there, so that you can actually make money instead of having tenants that are late on rent and then needing to pay a bunch of money to get the property back into shape. We really appreciate you watching this video. Leave a comment below if you have any questions about the that's not right, that needs to be updated, about the eviction process. And stay tuned for our next installment of our monthly webinar series. We're going to be discussing a bunch of other cool stuff coming up in the next couple of months, so be sure to stay tuned for that. If there are no questions, I'm happy to sign off. I don't even know how to get to questions, so let me see if I can somehow get back to Zoom. I think we're good. No questions here, so I'm going to sign off. Thank you guys for watching, and talk to you soon. Matt here, Keyrenter Tulsa, signing off.